electronic record come in court, sourced by the prosecution. Definitely, prosecution look into that as far as CBI is concerned. That yes, it should be considered as an evidence. But let me tell you, it's not going to be accepted as a gospel truth by the trial court, by the special court. वो ऐसा नहीं, the defense will get an opportunity, and if the defense has causant material in its hand, or it's in its hand, that yes, this electronic record is manipulated, etc., then you are getting all good opportunity to cross-examination to the witness. Witness may be the CBI officer, may be the police officer, or whomsoever it may be. So again, I am saying the opportunity would be there. It is not going to be accepted. That's what I am saying. This evidence act is to be presented before the court of law, before the judge. A judicial mind is sitting there to pass it, to evaluate the evidences, evaluate the material brought before the court. ये इस बात को मत भूलिए. हम यहाँ कोई ऐसा नहीं है कि एक बार बॉल मार दिया तो बाउंड्री के बाहर चली गई, नहीं जाएगी बाउंड्री के बाहर. यहाँ lots of checks and balances are there. It is not something in a routine. Something would be in a drastic manner. Something would be totally accepted or acceptable. No, not at all. ये चीजें तो इसको इस तरह से मत देखिए आप. ये ना काफी चेक एंड बैलेंसेस हमारे ट्रायल कोर्ट के सिस्टम में है. कोई भी चीज और देखिए, ट्रायल कोर्ट के सिस्टम को जाने दीजिए. अगर ट्रायल कोर्ट का लॉयर, डिफेंस लॉयर, मैं मानता हूं कि प्रोसिक्यूशन फ्रेम करेगा, मैं मान लिया आपकी बात. प्रोसिक्यूशन अगर फ्रेम करेगा तो प्रोसिक्यूशन भी प्रोसिक्यूट होगा. आप देखते हैं जब भी कोई गलत इनकाउंटर होता है, कोई भी घटना होती है, तो उन पर भी एफआईआर होती है. तो आप इन सब चीज, ये एक्सेप्शनल होता है, नो डाउट अबाउट दैट. लेकिन कौन करता है? कोर्ट ही करती है ना. तो इसके लिए कुछ भी चीजें, और जैसा हम सब बात कर रहे हैं, हमारा ओपिनियन है कि 80-90% सेम है. अब हमारे मल्होत्रा साहब ने बोला 95% है, तो वेरी ट्रू. अगर इतना है तो इसमें कोई ड्रास्टिक चेंज नहीं आया. बट लेट मी टेल यू, जो ड्रास्टिक चेंज आया है ना, टू माय माइंड इट इज अबाउट द कन्फेशन. और ठीक है, वो इलेक्ट्रॉनिक एविडेंस का, मेरी समझ से इलेक्ट्रॉनिक एविडेंस ये सबको प्रूव करने में बड़ी प्रॉब्लम होती थी. हम लोग को इन सब चीजों पे और प्रोसिक्यूशन को भी प्रॉब्लम होती थी. ये सारी चीजें काफी जुडिशियल प्रोनाउंसमेंट और प्रैक्टिकलिटी को देख के इन सारी चीजों को कंसोलिडेट करने का प्रयास किया गया. ये मेरा ओपिनियन है. So this is, I believe, sir. I believe I tried my best to answer your question.
This is not a question, sir. This जिसको कहे कि ये जो कानून के अंदर इसकी जोगवाई क्लियर नहीं है. Anyway, sir, Mr. Advocate Rahul has
कभी नहीं, बहुत से कानून में क्लैरिटी नहीं है. It is all by the judicial.
Yeah, exactly.
Clarity
that is what I meant to say.
And interpretation. Yes, sir.
Advocate Rahul is going to join any moment. Telephone. तो इन द मीन टाइम मैं इसी को थोड़ा सा लेके आगे बढ़ा रहा हूँ. हमारे जस्टिस राजू लोचन मेहरोत्रा साहब और अंजनी कुमार साहब दोनों के लिए आपने जो कहा उसी को लेकर बात करते हैं. 2021 का कर्नाटका हाईकोर्ट के अंदर एक गाइडलाइन इश्यू हुई, मिनिमम सेफगार्ड ड्यूरिंग द सर्च एंड सीजर ऑफ इलेक्ट्रॉनिक रिकॉर्ड. उसके बारे में है. उसमें कहा गया है, ensuring that a qualified forensic examiner accompanies the search team. Second is prohibiting the investigating officer from using the seized electronic device during search and seizure of electronic records. Third is seizing any electronic storage device such as pen drive or hard drives and packing them in a Faraday bag, that is where electronic signal do not enter. इस सब गाइडलाइन के बावजूद मैं जो लड़की की बात कर रहा था उसका नाम अभी याद आया, दिशा रवि. उसके कंप्यूटर्स के अंदर में सीजर्स भी हुए, सब कुछ हुए, बाद में डाला गया, एंड शी वाज देयर इन जेल फॉर नंबर ऑफ डेज और इयर्स. तो हम इसको क्या कहेंगे? मिसकैरेज ऑफ प्रोसेस ऑफ लॉ. अभी इसके अंदर नए एविडेंस एक्ट में हमारे पास क्या उपाय है, पता नहीं चल रहा है.
देखिए लॉ गलत नहीं बना है. इंप्लीमेंट करने वाले अगर पॉल्यूटेड माइंड के हैं तो उसमें हम लोग क्या कर सकते हैं? हम लोगों ने आपको एक पर्टिकुलर आदमी को 100 रुपए लेके सामान लेने भेजा और उसने जाके अडल्ट्रेटेड सामान खरीद लिया, ये बीच में अडल्ट्रेशन कर दिया, तो रुपए देने वाले की गलती नहीं है. हमने मंदिर में जाके पुजारी को मंदिर में जाके पैसा दिया, दान दिया, और दान के पैसे से अगर पुजारी शराब पी गया तो हम क्या कर सकते हैं? ये तो इम्प्लीमेंट करने वाले की प्रॉब्लम है. देखिए कोर्ट ने डायरेक्शन दिया. अब नेचुरल है कि जब एक बार ये सिस्टम बना है इलेक्ट्रॉनिक डिवाइस का, तो आप यकीन मानिए कि फॉरेंसिक टीम भी मजबूत की जाएगी। इसके साथ साथ में फॉरेंसिक टीम और डेवलप करके जो सीजर होगा वो उसके हिसाब से ही होगा, रेस्ट श्योर। एक बार शुरू होने दीजिए, इसको कोर्ट तक जाने दीजिए। कुछ केसेस छूटेंगे, प्रोसिक्यूशन फेल होगा कुछ केसेस में, केवल इन्हीं टेक्निकल ग्राउंड्स की वजह से कि साहब वो फॉरेंसिक टीम नहीं थी, या जिस तरह सीजर किया गया वहां सीजर नहीं था, या जहां पे था वह सिग्नलिंग नहीं थी। लेकिन 2-4 मुकदमे तय होने के बाद अल्टीमेटली प्रोसिक्यूशन भी मजबूत होगा, और इसी सेक्शन को, इसी एक्ट को वो मजबूत करके सामने आएगा। लेट अस होप सो।
और इसमें मैं एक चीज और ऐड करूंगा कि हाँ, इसमें यही मैं एक लाइन केवल ऐड करूंगा कि सारी चीज होने के बावजूद मैं तो बोलता हूं उन गलत लोगों के लिए जो पोल्यूटेड माइंड है, जिनको पावर मिला है टू डू द फेयर इन्वेस्टिगेशन, अगर वो इन्वेस्टिगेशन बराबर नहीं करते तो दे कैन बी प्रोसिक्यूटेड। लॉ इज देयर अगेंस्ट देम आल्सो। ये तो कई केसेस में हुआ है। केसेस में हुआ है कि कोर्ट ने ट्रायल में सीधा सीधा ये ऑब्जर्वेशन दे दिया है दैट प्रोसिक्यूशन हैज फेल्ड टू प्रॉपर्ली इन्वेस्टिगेट द मैटर एंड आई हैव टू अक्विट द अक्यूज। और प्रोसिक्यूशन के अगेंस्ट में काफी कमेंट आए हैं। प्रोसिक्यूशन की तो सीआर बिगड़ गई है, उनको कई ऑफिसर्स की तो नौकरी चली गई है। ऐसे ऐसे ऑब्जर्वेशन आए हैं कोर्ट के। तो आप मैं वही बोल रहा हूं कि हमारा जो सिस्टम है ना एज अ होल बहुत अच्छे से करेक्ट होते होते चेक बैलेंसेस के साथ अप टू सुप्रीम कोर्ट तक गया है। और हमारे पास 3 टायर सिस्टम है। ट्रायल में अगर सारी चीजें आ जाती हैं, गलत या सही सारी चीजें आ रही हैं, तो फिर वो हमें ऊपर भी जाने का मौका मिलता है। यहाँ एक ही चीज का ध्यान रखना है कि ट्रायल कोर्ट को लोग बोलते हैं, मैं नहीं बोलता। मैं तो ट्रायल कोर्ट को फर्स्ट कोर्ट बोलूंगा। मैं हमेशा ट्रायल कोर्ट को फर्स्ट कोर्ट बोलता हूँ। मे बी स्पेशल कोर्ट और कुछ भी लोग बोलते हैं लोअर कोर्ट। नेवर इट इज अ लोअर कोर्ट, इट्स अ फर्स्ट कोर्ट। सारी चीजें वहीं क्रिएट वेंड होती हैं। बाकी तो फिर तो एप्लीकेशन ऑफ माइंड होता है अपीलेट कोर्ट में जाके, हाई कोर्ट में और सुप्रीम कोर्ट में। सारी चीजें नीचे ही बनती हैं या बिगड़ती हैं। तो ट्रायल कोर्ट में अगर सारी चीजें बहुत सलीके से तरीके से आ गई तो मुझे लगता है न्याय मिलेगा। अब न्याय में आरोपी कन्विक्ट हो या अक्विट करे। और एक चीज मैं और बोल दूं, ये जो चीजें हो रही है ना, इनसे कन्विक्शन रेट बढ़ने वाला है। इनसे जो लोग मतलब ऐसे वकील जो लोग बहुत क्योंकि लॉ के इन्वेस्टिगेशन में काफी लूप होल्स होता था एंड वी यूज्ड टू टेक एडवांटेज ऑफ दैट। तो अभी आपको भी उसके हिसाब से एक फेयर अप्रोच लगा के आपको देखना पड़ेगा कि कैसे हाउ यू कैन गिव सर्विस टू योर क्लाइंट्स एज वेल। तो ये चीजें इंप्रूव हो रही हैं। वी आर ऑन द इम्प्रूवमेंट साइड। वी हैव टू लुक वेरी पॉजिटिव एंड ऑन इम्प्रूवमेंट साइड। कन्विक्शन बढ़ेगा और न्याय जल्दी भी मिलेगा, इसका डिस्पोजल भी होगा, ऐसा मेरा मानना है। और इस सब में थोड़ा टाइम लगेगा, इसमें कोई शक नहीं है।
Agree, sir. No comments.
Where is Mr. Raghavan? He has come.
Yeah, he has already joined. Yeah. So शिवानंद भाई, राघवन सब ज्वाइन कर लिया।
नमस्ते।
Advocate Raghavan,
I wanted to see your face, my dear.
No, it's my face is there, no?
Now I have seen your face. Yes.
कर्नाटक के अधिवक्ता हैं, एडवोकेट हैं, और आपका स्वागत है। और प्लीज अपनी बात आप आज के विषय पर रखें। सुन पा रहे हैं? हमें लगता है कि राघव साहब।
हाँ जी, यस, नमस्कार। एक्चुअली मेरा तो आज दूसरा सीनियर के एडवोकेट के पास अपॉइंटमेंट था, थोड़ा देर आने के लिए क्षमा चाहता हूँ।
Yeah, Hindi is good.
Yes, actually this particular evidence act, that's a new evidence act, they say that it is a replacement for the evidence act. Actually, according to me, when I gone through the evidence act of present thing, I never found any major changes, or it cannot be replaced. What is replacement? One act to the other act. Actually, it is not so. I think it is not only wherever they have done something because of the introduction or inception of the electronic and media, and they brought some amendments. Actually, rather we can able to say that instead of replacement for the Evidence Act, we can say that the amendments have been carried out, And only the thing is, instead of this Evidence Act, they given a new name called that Bharatiya Sakshiya Nyaya they given. So only the thing, this is the changes they brought it. As the thing is, instead of Evidence Act, they say that Bharatiya Sakshiya Nyaya. So I never found any major in the thing. As far as the cause title, the title of the act is been changed. And some of the changes like, because today's, what is a requirement as of 1972 and earlier those days, the media and electronic media was not there. Now this is the thing major, it is a thing, that is what they made an amendment. I am not against to that, talking against to that parliamentarians or anything. Yes, they have been taken the thing all into the interest and they made some changes. So that is, they could have been declared or they could have been called as an amendment, but they say that it is a replacement. Even if you go legal language, it is not replacement, it is only amendment, we can say that. That is number one. Now, let me get into this root cause of the Evidence Act. When the inception has been there, when the history goes, actually, just I will read it from the thing, what to say that from one of the thing, evidence, how this Evidence Act came into the picture. Actually, this evidence is not new to the human beings. Actually, it is there from the very, very long time, long time it is there. From the evidence, traces from the Vedic period. What is the evidence? See, whatever we had to do, there should be some kind of a proof must be there. Yes, the proof should be authenticate. Not like any, the thing is not like I have seen, I have done it. That is not a thing. Actually, this Evidence Act, it is when it is come to the Judicial Act, and there should be a authentication must be there. Just I will read from one of the thing, or just when I got the downloaded from the thing, the law of evidence in India traces back its roots to Vedic period. So Vedic period means, even you can say that easily everyone knows that 5,000 years back it is there. It is not a new, but that time we never say that in the English, what we say that, what to say that, given the name called evidence, in the, we say that it is a Dharma Shastra. So Vedic period, Dharma Shastra, in order to ascertain the truth, see, truth is very much important. See, we speak certain time, we have to be truthful to this, any judicial thing, judicial cases. So this is what the truth, they say that. So it is a thing is when we say that it is a dharma, ascertain the truth, and it was also an important integral part of the judicial proceedings. So any judicial proceedings, when we go that, we had to be truthful to oneself, ourselves, and everything. So without this, even we cannot able to zero in the what is we cannot able to zero. It becomes a very difficulty to zero the identification of the cases if one is not truthful to the court or oneself. See, more than anything, more than to others, we have to be truthful. If I am speaking before this, I have to be truthful to myself. Let me not go to the comparing to the others. I had to be truthful what I am saying before. So that will become the truthful to others also. So that the judicial proceedings can able to take the evidence truthful, then they can able to ascertain case, then it comes to the, in the form of what exactly to be punishment has to be given. So this is what the Dharma Shastra says that. Dharma Shastra is a say, we had to go by Vedic only. And we are all know that the India is also believed to be the Hindu or Hindu Succession Act. So we are all Indians. So this is where the thing is evidence comes. Now, as far as the present, that's what we are Bharatiya Sakshiya Nyaya. So the evidence, what they say that major the amended is for the, see, today whatever they speak, they have been interpreted and they brought in law into the 2023. It is already, see, practically I'm speaking now, because of electronic media and email, email, everything, what we are going to do as an advocate, what I am doing that, if I am taken certain documents where I am going to rely on the thing, certain documents, it is in the form of secondary evidence. It is not in what is primary evidence? A primary evidence should be the original document or the certified document issued by the authority, concerned authority. It may be a government or it may be a corporation or anything. In absence of these two, the second, we had to rely on the evidence. The rely on the evidence, what secondary evidence, whatever the available document we had to produce before the court. What is a procedure? Procedure is there. This is a document. It is in the form of secondary evidence. In absence of the primary document, I am producing it before the court. So you give a permission or leave to produce as and convert it as a document. What is, see, suppose if it is in the document called electronic document. What is an electronic document? See, today it is a Companies Act, so many acts and certain documents. Then early in those days, we used to write the letter by our own handwriting and we used to sign even that document also. Today it is not happening. Everyone type it in the thing. Even me also. I am not going to others. Me also type it certain things. I will send it to the thing. So that will become a document. But that is not correct. What we have to do means, suppose if I have received some letter from somebody, I have seen in my computer or PC or laptop, I have to mention it. And in my office, I have got the that printer name also has to be, it is there. That is whatever the thing, LQ or something, I have taken the printout. As such, it has become, please treat it as a document. This is how we are going to make it in the form of certificate. What is there is a procedure is there. That is a section is there, section 65 or 63 to 65 of the Indian Evidence Act. Yes, this they have been amended. This is a major amendment. They have done it. So this secondary evidence can be treated as a primary, as good as primary evidence. Now, majority of the judicial system, it runs in the form of evidence, proof. Whatever the dying death, suppose a person is dying, the death is dying, that person is also has to give a whatever evidence. It is not that if he speak even one word during the time of the death, that is also called as a evidence. But now what they say that the present amendment, or it can be say that replacement, they are given as something like punishment for the false evidences. Anyway, that's still the whatever the punishment, everything, some punishments they have been given it, they have been strict. But actually, when a proceedings is going to happen in a one proceeding, if the court comes also, the person who is speaking the thing, if the measurement of the false evidences, that cannot be punished in the same proceeding. But this present, what you say, that present amendment or the thing replacement, they have done some thing, they are given it thing that some punishment they are also given it. So this about the thing. And as far as the Evidence Act, wherever I go, that in the present, see, today I also advocate for various the courts like consumer court or criminal court, there's magistrate courts or civil courts. Wherever such kind of a thing, we are taking a lot of cautious. And first the procedure is to go and file an application before the honorable courts with the present document. And we had to give a reason why can't we produce the original document? It is in the form of original, whether we lost the original document or this is the document is it is with some government authority. As such, we cannot able to produce it. So that reasons has to be given. And it is a discretionary of the court whether to treat this as a secondary evidence or they can also reject it. But certain documents where we lost the documents, see, in those days, especially the will, will is not mandatory for the registration of the will. Even just in the handwritten will also can be treated as a virginal will. But suppose when we go before the court, we had to mark the will, means wherein court will say that, the judicial system say that who is the author of the will and who is the witness who has seen that writing the will. But suppose in case we have been finding a difficulty also. Suppose there is a will is been in existence, the author of the will is no more, and even if it is the will that witnesses who has been seen witnessing and witness persons are there, if even in there also, if the 2 witnesses have been signed and even there also been what you call that they are also been died, then in such circumstances what exactly to be we had to do, and again it will also become a difficulty to for the even judicial courts also. So these are the things we had to be in go get into this. The thing is wordings, everything, and we had to see the relying on the testator of the will and author of the signatures and all. Finally, the court can come to the conclusion that whether it is authenticate or not, and then they can treat it as a secondary evidence. So as long as this particular system, that's the thing, any court, whether it is a judicial or non-judicial, the proof is very much important, and whatever the thing is, it should be a truthful. So this is only the thing is certain thing. See, even I'm not going to elaborate it in this particular thing. Largely I'm not going to elaborate it, because even this present amendment, we can say that, and certain what is sections brought newly that, anyway, we had to, the thing is we are all, even earlier previous also, when I was talking to the thing in the webinar, we had to go steady, and we had to do the advocates, a group of advocates, senior and judges, everything, and we had to make some submission or something to the court of law. Then it is left to this court of law, and we can able to brought some changes or amendments in the present act also. This is about my view of this particular act.
धन्यवाद राघवन जी आपके विचारों के लिए कार्यक्रम में। प्रवीण सर, कुछ आप इसमें बात रखना चाह रहे हैं? हमारे बीच में क्या एडवोकेट पूनम चंद भंडारी साहब आ चुके हैं, तो उनको बुलाया जाए?
मेरे को नहीं लग रहा है।
तो ठीक है, हम इसमें आगे चले। हाँ, यदि कोई क्वेश्चन हो आप लोगों के पार्टिसिपेंट्स के, कोई क्वेश्चन हो,
पीसीजीटी से किसी को बुलाना हो तो देखिए।
पीसीजीटी से हमारे जो साथी जुड़े हुए हैं, यदि वो अपनी कोई बात रखना चाहते हैं तो प्लीज स्वागत है। तो यदि आप ही नाम, कोई विशेष स्पेसिफिक नाम प्रवीण सर अनाउंस करना चाहते हैं तो उनको प्लीज आप।
उनकी चॉइस है। एनीबॉडी फ्रॉम पीसीजीटी लाइक टू शेयर सम व्यूज?
ठीक है, तो कार्यक्रम में हम आगे, हमारे बीच में वीरेंद्र ठक्कर साहब जुड़े हुए हैं। वीरेंद्र ठक्कर उत्तराखंड से आरटीआई रिसोर्स पर्सन है, और लास्ट में आप लॉ की डिग्री आपके पास है, मतलब आप रखते हैं। आप हालांकि प्रैक्टिसिंग एडवोकेट नहीं है, आप गवर्नमेंट सर्विस से जुड़े रहे हैं, और वर्तमान में आप कंप्यूटर साइंस एजुकेशन के आप प्रोफेसर भी हैं, एसोसिएट प्रोफेसर। तो वीरेंद्र कुमार जी, शॉर्ट में अपनी बात प्लीज आप भी अपनी बात प्लीज रखें कार्यक्रम में, इंडियन एविडेंस एक्ट के विषय में।
धन्यवाद। हाँ जी,
आप सुन पा रहे हैं? हाँ,
आई होप माय वॉइस इज क्लियर। पहला जो पॉइंट था, दैट वाज रिगार्डिंग कंसल्टेशन प्रोसेस। तो रिगार्डिंग कंसल्टेशन प्रोसेस, आई वुड लाइक टू टेल दैट 5 ईयर हिस्ट्री ऑफ दिस एक्ट, कि 5 साल से 2018 के बाद क्या क्या हुआ है। द parliamentary committee has submitted 1200-page reports for all these 3 acts. So about Evidence Act, they have stated the bill was drafted with utmost care, keeping in mind their implications on the citizenry for the years to come. During the drafting process, suggestions were sought from governors, all governors, chief ministers, lieutenant governors, administrators of states and union territories, the views and inputs of the Chief Justice of India, Chief Justices of all high courts, bar councils, law universities, institutions and members of parliament were also solicited. Further, the Central Bureau of Investigation (CBI), Intelligence Bureau (IB), Bureau of Police Research and Development (BPR&D), Central Police Organization (CPOs), and more than 1,000 police officers from various states also submitted their suggestions. This included 1,000 IPS officers. A committee under the chairmanship of the Vice Chancellor, National Law University (NLU), Delhi was constructed on 2nd March 2020 to examine and suggest reforms in criminal laws. One of my teachers in Lucknow University, Professor Balraj Chauhan, was also a member who was involved in this process since 2018. The committee had invited suggestions from various quarters, including public and considered suggestions from high courts, experts, research centers, academicians, lawyers, civil societies, law universities, etc. from across the country. The suggestions received from states, union territories, the Supreme Court, High Courts, judicial academies, law universities, and members of parliament were also forwarded to the committee. In para 2.4, the parliamentary committee said, the committee, under the chairmanship of Vice Chancellor NLU Delhi, after extensive consultations with stakeholders and in-depth research, submitted its report in February 2022, containing its recommendations. A total of more than 3,200 suggestions were received by the committee, which were consolidated in the report submitted by it. तो ये तो consultation process का brief history हो गया. Regarding this admissibility of electronic evidence, तो electronic evidence में, since I am computer engineer also besides being a criminal lawyer, तो इसमें certificate A में change किए गए हैं. Actually the previous schedule was already repealed. तो अब जो नया schedule इसमें add किया गया है, that has got two forms. These are called certificate A, certificate part A and part B. तो दो अलग अलग जो इसमें ऐड किए गए हैं सर्टिफिकेट्स, तो जो भी डॉक्यूमेंट के टेम्परिंग ना हो, इसके लिए क्या प्रोविजंस किए गए हैं. सो रिगार्डिंग दिस, new certificates have been introduced which were not there in the previous one. So a new schedule has been added to the act, and in this the certificate have been introduced. Now this certificate has got two parts. One is to be submitted by the party, second is submitted by the expert. ये सर्टिफिकेट में क्या लिखा जाता है? Because पहले 65B था. Now these certificates are submitted under section 63 subsection 4 clause C. इसका जो part A है, I, name, son, daughter, spouse of residing employed at so and so, do hereby solemnly affirm and sincerely state and submit as follows. I have produced electronic record or output of the digital record taken from the following device: digital record source, tick mark, computer or storage media, DVR, mobile, flash drive, CD, DVD, server, cloud और other. Other का फिर mention करना पड़ेगा. And make and model, color, serial number, IMEI, that is International Mobile Equipment Identification for mobile phone, UIN, UID, MAC, message जो ये है authentication code, cloud ID as applicable, and any other relevant information, if any, about the device, digital record specify. So I will not go into technical details of this, क्योंकि generally हमें final year computer science and engineering वालों को बताते हैं. Further, the certificate has a declaration: the digital activities, and during this period the computer or the communication device was working properly and the relevant information was regularly fed into the computer during the ordinary course of business. If the computer or digital device at any point of time was not working properly or out of operation, then it has not affected the electronic digital record or its accuracy. The digital device or the source of the digital record is owned, maintained, managed or operated by me. Select as applicable. इसके बाद कुछ हैश एल्गोरिथम्स के बारे में कहा है. तो दिस इज रिलेटेड टू कंप्यूटर मैथमेटिक्स. आई स्टेट दैट द हैश वैल्यू, इससे टेम्परिंग पता चलता है. मैं ये नहीं बोल रहा हूँ कि टेम्परिंग नहीं किया जा सकता, बोल रहा हूँ कि टेम्परिंग किया जाता है तो इट इज डिटेक्टेबल बाय फॉरेंसिक एक्सपर्ट्स. आई स्टेट दैट द हैश वैल्यूज ऑफ द इलेक्ट्रॉनिक डिजिटल रिकॉर्ड्स इज obtained through the following algorithm: SHA-1, that is secure hash algorithm 1, SHA-256, that is 256 bits होते हैं इसमें secure hash algorithm में, MD5 ये message digest 5 है. All computer engineers in India know about this because it is compulsory subject in final year. BTech. Other, that is legally acceptable standard. So hash report to be enclosed with the certificate. जैसे प्लेजियरिज्म में भी सॉफ्टवेयर की रिपोर्ट होती है, जस्ट लाइक दैट देयर इज दिस हैश रिपोर्ट, जिससे टेम्परिंग ये जो हैश मैच होता है कि नहीं देखा जा सके. Name and signature, date, and then time, that is IST, in 24 hours format and place. Part B जो है, that is to be filled by the experts. So importance of forensic experts and computer engineers is going to increase day by day, because at all in all district, it is estimated around 35,000 forensic experts will be required the world over, and forensic universities have already been established in many places throughout India. So name, son, daughter, spouse of this residing, employed at, do hereby solemnly affirm and sincerely state and submit as follows. The produced electronic record or output of the digital record are obtained from the following device: digital record source, tick mark, that is computer storage media, DVR, mobile flash drive, CD, DVD, server, cloud, other का make, model, color, ये सब mention करना पड़ेगा, serial number, and then IMEI, UIN, UID, MAC or cloud ID as applicable, and any other relevant information, if any, about the device or digital record that has to be specified. Regarding this will or वसीयतनामा जो राघवन साहब ने बताया, so वसीयतनामा और जो will has to be manual as per schedule 1 of the Information Technology Act 2000. Under IT Act, वसीयतनामा मैनुअल होना कंपलसरी है, it cannot be electronic. So schedule 1 specifies the exceptions to the IT Act, that is things that cannot be are not admissible under the IT Act. So जो admissible है, that is mentioned in say sections 6 to 10 of IT Act, and schedule 1 gives the exceptions to that, that is जहाँ पर electronic evidence बिल्कुल नहीं चलेगा, and जहाँ पर compulsory करना है, so by an act to be enacted by the parliament, the central government can do away with the manual procedure. So that has to be done by law only. जैसे कि income tax filing में किया गया है, or maybe in say biometric attendance, the manual attendance register has to be done away. So if the manual system has to be abolished, that can be done only through act passed by parliament. Otherwise, everywhere section 6 to 10 of IT Act specify कि electronic records are admissible as manual records, electronic gazettes are admissible as electronic say manual gazettes, electronic fund transfer, money transfer, that is admissible as manual funds transfer. So all this is mentioned in IT Act, or things where the IT Act does not apply. So these are mentioned in the schedule 1 of the IT Act. So वसीयतनामा उसमें included नहीं है, but in future land records जैसे land record भी अभी है कि it has to be manual, land records are not admissible, but digitalization हो रहा है, and the central government through an amendment to IT Act may add say entries to this schedule 1 or delete some entries from schedule 1 of the IT Act. So this is as far as the technical details that I wanted to add as a computer engineer. इससे related किसी के कुछ questions हो यदि हो, so I will be happy to answer these questions. Regarding this percentage changes, my view is that जो changes इसमें हुए हैं, so I have prepared all these comparative charts of all these 3 acts myself without any help in August 2023 itself. और उसके बाद फिर कुछ changes आए हैं. Now these are available on many other websites on internet also. तो इसमें जो changes किए गए हैं, particularly in this Indian Evidence Act, some of the changes are prominent. इसमें जो changes हुए हैं mainly, so the changes that I have found out is that क्योंकि percentage यदि calculate करना है, there should be some methodology to calculate it. So 24 ये साक्ष्य अधिनियम में 24 sections have been amended. Amended means changed. 2 new sections and subsections have been added. That is the new additions. 6 sections have been repealed. So if we add these 24 plus 6 plus 2, that is 32. And earlier there were 167 sections in Indian Evidence Act, and 18 sections were added through amendments. That means there were say 185 sections in 11 chapters in 3 parts. Now there are 12 chapters in 4 parts, and there are 170 sections. So the size has reduced from 185 sections to 170 sections. क्योंकि amended से जो add किए गए थे वो भी देखना पड़ेगा. 149 sections have been left untouched. That means 13% of Indian Evidence Act is changed and 87% it is the same. If we compare with the same methodology with the Indian Penal Code, that is Bharatiya Nyay Sanhita, and Indian CRPC, that is Bharatiya Nagrik Suraksha Sanhita. So इसमें जो changes हुए हैं, so in Indian Penal Code, that is Bharatiya Nyay Sanhita 2023, if we see the changes, so 21 new offences have been added. Term of imprisonment has been increased in 41 offences. Fine has been increased in 82 offences. I have made a comprehensive list of this. Mandatory minimum punishment has been introduced in 25 crimes. Provisions of community service as a punishment in 6 crimes. इसकी भी list मैंने बनाई है. Repeals 19 provisions of IPC 1860. Changes 175 existing provisions. Introduces 9 new sections, and now there are 358 sections in 20 chapters. IPC had 511 sections plus 63 sections were inserted through amendments. That means there were 574 sections. Compared to that, and there were 23 chapters and 3 chapters were introduced through amendments. So 184 sections of the IPC remain unchanged. That means 64% of Indian Penal Code has been changed. This is the methodology of my calculation. क्योंकि जहाँ थोड़े बड़े भी changes हुए हैं, so I have calculated everything. If we compare the CRPC with Bharatiya Nagrik Suraksha Sanhita, so in CRPC 177 sections have been changed. 39 new subsections have been added. So complete sections जो change हुए उसमें भी कुछ subsections add किए गए हैं. 14 sections have been repealed. I have made a list of all these sections that have been repealed. Timeline have been added in 35 sections because there are some timelines for all the 4 pillars of criminal justice administration, that is for police, prosecution, judiciary as well as jail. So timelines have been added in 35 sections. कुछ फॉर्म भी चेंज किए सेकंड शेड्यूल में. 56 फॉर्म्स आर देयर, सो 41A जो था, so that form has been also changed as form 1 of second schedule. 531 sections are there in 39 chapters. थोड़ा चेंज हुआ है बिल के बाद, सेकंड बिल इंट्रोड्यूस हुआ था and then the bill introduced in Lok Sabha and finally it has come into an act. CRPC had 484 sections and 51 sections had been added through amendments. तो इस तरह से 535 sections CRPC में थे. Now the size has reduced. There were 37 and 2 chapters were added. CRPC में पहले 2 शेड्यूल थे, अभी भी 2 ही शेड्यूल है. But of course first schedule has changed drastically because जो सेशंस कोर्ट के पावर से वो चेंज कर दिए. तो जो कोर्ट्स जो शेड्यूल में लिखा होता है कि बेलेबल, नॉन बेलेबल, कॉग्नाइजेबल, नॉन बेलेबल, ट्राइबल बाय विच टाइप ऑफ मैजिस्ट्रेट, तो जो ट्राइबल बाय विच टाइप ऑफ मैजिस्ट्रेट है इसमें बहुत सारे चेंजेस है एंड देयरफॉर शेड्यूल 1 हैज चेंज. CRPC 320 और 321 में कंपाउंडेबल एंड कंपाउंडेबल विद द परमिशन ऑफ द कोर्ट जो थे, इसमें भी काफी चेंजेस हुए हैं. 364 सेक्शंस रिमेन अनचेंज्ड, कि जिसमें कोई भी चेंज नहीं है. सो बाय दिस मेथोडोलॉजी 32% ऑफ CRPC हैज चेंज. सो दैट इज माय कैलकुलेशन मेथोडोलॉजी. तो इस तरह से ये जो 3 चेंजेस 3 एक्ट्स है जो amendment ki why new acts have been brought and why it has not been through amendment. So I have not seen an amendment act of 400 sections. Amendment यदि इतना ज्यादा हो कि आपको 200, 300, 400 सेक्शन अमेंड करने पड़े, so it is better to even जो once the bill was tabled in parliament in October 2023, उसके बाद जो पार्लियामेंट्री कमिटी ने जो इसमें changes suggest kiye, plus there are say some dissent notes mainly by Adhir Ranjan Chaudhary and say leaders of oppositions. तो ये जो changes इसमें suggest किए गए हैं, इसमें भी इतने ज्यादा changes थे that the first ad had to be withdrawn by the government and then the second ad was reintroduced. So it was impossible कि 400, 600, 800 एक्ट का सेक्शंस का अमेंडमेंट एक्ट कोई ले आता. Therefore it was I think justified कि पुराने बिल को रिपील करके एक नया ड्रास्टिक चेंज किया गया. हाँ, अमेंडमेंट इंडियन एविडेंस एक्ट में चेंजेस बहुत कम है एज कंपेयर टू से BNS एंड BNSS, बट यदि वो सिंस वी कंसिडर इट एज क्रिमिनल मेजर एक्ट्स और क्रिमिनल मैनुअल, तो फिर 2 बदल देते और एक को नहीं बदलते, तो फिर इसमें प्रॉब्लम होता था। एज फार एज द केस लॉ, कि जो केस लॉ का क्या होगा कि सुप्रीम कोर्ट और हाई कोर्ट के जो जजमेंट्स है वो आर पास्ट 160 ईयर्स, आई मीन इंक्लूडिंग प्रिवी काउंसिल जो 1950 के पहले था, दैट इज बिफोर एस्टेब्लिशमेंट ऑफ सुप्रीम कोर्ट ऑफ इंडिया, तो प्रिवी काउंसिल के भी इसमें ऐड कर लेते हैं। तो ये जो जजमेंट्स थे, इन जजमेंट्स का अब क्या होगा? सो जो प्रोविजंस चेंज नहीं हुए वहां पर जो केस लॉ है, एज पर माय अंडरस्टैंडिंग, दोज विल रिमेन वैलिड। Some of the judgments of Supreme Court have already been incorporated in the new laws because suggestions from many judges of Supreme Court and High Court were also invited. तो जो केस लॉ में था वो सब इसमें आ गया है। एंड जहां पर कुछ ऐसे भी है कि दे हैव ओवर रूल्ड, सो दैट इज द पावर ऑफ द पार्लियामेंट कि और वी कैन से कॉन्फ्लिक्ट बिटवीन एग्जीक्यूटिव एंड जुडिशियरी, की जहां पर जुडिशियरी का जो इंटरप्रिटेशन था, जैसे निर्भया गैंगरेप केस में रात को कोर्ट खोला गया था, अब ये सब चीजें नहीं हो सकती बिकॉज कोर्ट में कर दिया गया है कि डेथ सेंटेंस के बाद जो अपील है तो सम रिस्ट्रिक्शंस हैव बीन इम्पोज्ड ऑन सुप्रीम कोर्ट और हाई कोर्ट, ताकि इस तरह का जो मैनिपुलेशन जो है ये ना कर सके। सो दिस हैव बीन चेंज्ड and we can say it is supremacy of the parliament over judiciary, they have changed, and now since these have been changed, the judiciary is bound to accept it unless it is declared unconstitutional. तो अनकॉन्स्टिट्यूशनल तो वो तो अमेंडमेंट्स भी होते रहते हैं, केस लॉ भी नया नया आते रहेगा। सो दी चेंजेस वेयर गो ऑन। पार्लियामेंट्री कमेटी जो थी, ब्रिजलाल द रिटायर्ड डीजीपी ऑफ उत्तर प्रदेश वाज द चेयरमैन ऑफ दिस। राज्यसभा के जो मेंबर्स थे दैट इंक्लूडेड श्री विप्लव कुमार देव, दे आर फ्रॉम ऑल पार्टी। स्टैंडिंग कमेटी इंक्लूड्स मेंबर्स फ्रॉम ऑल पार्टी, श्री एनआर एलांगो, डॉक्टर अनिल जैन, श्री सुजीत कुमार, श्री नीरज शेखर, श्री दिग्विजय सिंह, श्री राकेश सिन्हा, श्री डेरेक ओ ब्रायन एंड श्री पी चिदम्बरम। लोकसभा मेंबर्स इंक्लूडेड श्री संजय भाटिया, श्री अधीर रंजन चौधरी, डॉक्टर श्रीमती काकोली घोष दस्तीदार, श्री दिलीप घोष, श्री दुलाल चंद्र गोस्वामी, श्रीमती किरण खेर, थिरु दयानिधि मारन, श्री राजा अमरेश्वरन नायक, श्री रंजित सिंह नाइक निम्बालकर, श्री जामयांग सेरिंग नामग्याल, श्री गजेंद्र सिंह पटेल, श्री लालू भाई बाबू भाई पटेल एंड श्री आर के सिंह पटेल, श्री विष्णु दयाल राम एंड श्रीमती शर्मिष्ठा कुमारी सेठी, श्री राहुल रमेश शेवले, श्री रवनीत सिंह, डॉक्टर सत्यपाल सिंह, श्रीमती